Y'all just let me know which party y'all think supported it. Slavery. The Democrats supported it. The Republican Party actually was created to oppose and reject slavery. The Democrats supported slavery. Republicans, majority of them, are the ones who went on to abolish slavery. Jim Crow laws and segregation.
You would think
the Democrats supported that. The Confederate flag. When we all see the Confederate flag today, we kind of already know what that means. I'm gonna kind of stay away from you. And at the time, the Confederate flag was a symbol of resistance to civil rights. The Democratic Party supported that.
And they now treat MAGA, the MAGA brand, like the Confederate flag or support of Trump. They look at you as a Confederate flag.
They came up with that symbol for us. White supremacy. Ooh, that's talked about a lot. That was founded by who? Democratic Party. Yeah. The KKK. Founded by the Democratic Party.
It's a big one.
And there was actually a point in time leading up to the 1930s where majority black voters were Republican because the Republicans were fighting for civil rights. And Republicans, majority of them, were the reasons that the 13th through 15th Amendment were passed. The 13th Amendment being abolishing slavery. But in the 60s is when the party started to shift. That's when LBJ, who was a Democrat, passed the Civil Rights Act, which actually was majority supported by Republicans. Obviously, LBJ was the president, so he took the credit. This was the turning point for the Democratic Party because they pretty much embraced the civil rights identity. We're the ones that passed the Civil Rights Act. We have your best interest because we did that, and they pretty much ran with it. And then in the 80s and 90s, the Republican Party stopped focusing on race and started focusing on the economy. And that actually drove majority of the black folks to the Democratic Party because the Democrats continued talking about race, Civil Rights Act. We do this for you, that for you. So now in the 90s, the Democrats had the majority black vote. From the 90s and up, it's pretty much the same thing. The Republican Party is majority white. The Democratic Party is majority black. But I said all of that to say this, though. I'll never be somebody that tells somebody else who to vote for. Vote for whoever aligns with your beliefs and values the most. Who I am talking to, though, is the folks that got these loyal ties to the Democratic Party and vote with blind faith just because it's Democratic. It is completely okay that the Democratic Party does not have your best interest anymore. The same way these folks didn't care about black people for a long time and then they switched and then all of a sudden want to act like they cared about black people all along. It's the same way you can just switch to another side because your interests have changed. You can see it in the history. People flip sides all the time. People voted for Republicans because they were doing the right thing and it was aligning with their morals and beliefs. Then they flipped to the Democrats and did that. You can do the same thing in 2025. It is okay to flip sides if one side is tripping, and the Democrats are tripping. And if the Republicans start tripping, you can also switch sides then. We got to get out of this whole one side is forever evil and one side is forever good. It's not like that, bro. Do whatever aligns with your morals, values, and beliefs, and never compromise it and vote blindly because your great grandma told you to.
This link will be below this video right here. And I really want to just express that. Shout out to the young man. He obviously was raised properly. Shout out to his family. But he's 1,000% right. But the other side just feels like, yo, if you're black and you're at a point where you're even understanding of the other side, then you're not for us. If you're willing to have a conversation with the ops, then you're an enemy. They look at everything like our line in the sand is, do you support us or not? Because we ready to fight and we don't trust you if you don't believe exactly what we believe over here. And he's letting you know, maybe what you believe is all lies. Maybe what you believe has been fed to you for a long ass time so that another group of individuals could benefit and not you. When we look at DEI, who benefits the most? Is it black people or is it white women? Feel free to go look into it. But before you do, I'm just going to let you know it's white women. But we'll fight for it. We'll fight for it and fight for it. We'll fight for abortions, realizing that it does kill millions of black babies. So at the end of the day, it's like, who's really fighting for you? Who's really fighting for you? And who's fighting against you? Who's telling you that you can't do it without government aid? And who's telling you that you can do it as long as you just apply yourself? Who's telling you that? Usually the coach that you have, basketball coach, football, volleyball, tennis, whatever, they usually tell you to dig deep and find that part in you that's a fighter. That would challenge the opposition. You know what I'm saying? Not ask them for anything, but go after what's yours. That's the type of coach that we wanted, and that will win some games. And that's the type of coach that we will put our own kids in front of when it's time for them to play sports or to do something, athletic or anything that has to do with competition or getting better. We want you to challenge our kid. For instructors and teachers, professors, we want them to challenge our kids, not just do what they to protect their feelings and give them a basket weaving degree, and they can't take care of themselves when they get out of school. Just to say, look at you, you're so intelligent, you got a degree, yay. Nah. So you got one side that's trying to protect you and they get off the backlash, then you have another that claim to protect you, but they're actually going in your pockets and taking advantage of you and don't care that you're killing each other inside of your cities. But they say, but we'll give you a paycheck we'll take care of some of y'all as long as y'all take care of us. It's like a pimp game. All right, now check out this young man right here. He has a message to Trump, to President Trump, and everybody that support him. Check this out.
This message is for Team Trump and the National Guards. Come to Atlanta. Come to Atlanta. Come to Atlanta next. I know y'all done cleaned Memphis up. I see so many videos of Memphis motherfuckers happy. As a homeowner, as a working man, as an entrepreneur, come to Atlanta. I beg of you. Get these YNs off these streets. Get these water boys off these streets. Come on. Because these males ain't doing shit. These motherfuckers ain't doing shit, Trump. Come to Atlanta. National Guard. Come on. Get these young niggas out of here. Get these YNs out of here. Come on.
Out of here.
Come on. National Guard, I see the work you doing in Memphis. I'm not one of them niggas. I'm a black man. I'm not a nigga. I'm a black man. I ain't like these other niggas. I don't give a fuck about all that what the niggas say. I care about me walking outside. Well, walking my dog without having to walk with a goddamn pew-pew. Bring Atlanta back. Bring old Atlanta back. Get rid of these YNs and these single mom raising them. So let's do it, Trump. Bring the National Guard to Atlanta and send them motherfuckers right down there by the goddamn Mercedes-Benz Dome. Let them sit right there, all through West End. Stay on up through there, all through West End by the Krispy Kreme. Right there. Park it right there by the West End Mall. Get them all. Get them.
My man said, I want to walk my dog without a pew-pew. And you know what? I feel the same exact way, man. I don't want to get shot, and I don't want to shoot anybody. I don't want to hurt anybody's kid. At the end of the day, I think that, and I honestly don't want police to have to be everywhere. Like, you have to be present in order for us not to hurt each other. What type of society do we have? Think about that. What type of society is that? They keep on saying, I thought that the conservatives wanted smaller government, wanted less. It's like, we don't want them involved. But they have to, because your mayors ain't doing nothing. They're not helping. They're not making matters better. And if they are, please let me know. I know they were saying, well, Baltimore's numbers are going down, so we don't need them. DC's numbers were already going down, so we don't need them. Well, when they was in DC, a whole bunch of residents, I know the YNs didn't like it, but some of the old folk were speaking out. Like, I was against it too at first, but this is the cleanest I've ever seen DC, the quietest I've ever seen, and I can just enjoy myself. I don't have to worry about. You had some young people that was posting about it too. Like, man, I ain't even got to tuck my chain.
ICE agents in Chicago. The order prohibits ICE from operating on city-owned property. We begin there this morning. I'm Lourdes Duarte in for Patrick Elwood.
And I'm Dina Bair. Thank you for joining us. Judy Wang is live at the Westside Justice Center with more on our top story. Judy?
Mayor Brandon Johnson says he considers this another step toward accountability, that more drastic action is needed to rein in what he called a rogue administration. This morning here at the Westside Justice Center, the mayor signed the ICE-free zone executive order. The order makes it illegal for federal immigration agents to use city-owned property for their operations. On display, a sign that will be posted at places that include CPS and Park District parking lots. The order does not direct Chicago police to get involved if agents violate the order. The mayor says it lays the groundwork for the city law department to take those agents to court. As justification, the mayor pointed to last week's raid of a South Shore apartment building. Agents arrested 37 people. Children were present. Some residents were held for hours. The Department of Homeland Security says some of those people had criminal records. Also, Saturday's shooting of a woman by agents at 39th and Kedzie in Brighton Park. Homeland Security says agents were forced to defend themselves because she was carrying a semi-automatic weapon. She is one of two people facing federal charges. Today's order was the mayor's third in connection with Operation Midway Blitz.
We have a rogue, reckless group of heavily armed mass individuals roaming throughout our city that are not accountable to the people of Chicago. Their actions put all Chicagoans at risk. When protesters confronted federal immigration agents in Brighton Park on Saturday, they were met with pepper balls and more repression. The fact is, we cannot allow them to rampage throughout our city with no checks or balances. Nobody is above the law. If we break the law, you should be held accountable. If Congress will not check this administration, then Chicago will.
We have reached out to the Department of Homeland Security for a response to the mayor's executive order. Also, regarding the National Guard deployment, a Defense Department memo says 300 Illinois Guardsmen will be deployed. On top of that, 400 Texas National Guardsmen will be deployed to Illinois, Oregon, and other locations to protect ICE and Border Patrol officers from protesters. Now, this morning, Illinois Attorney General Kwame Raoul announced that he has filed a lawsuit against defendants that include the president, DHS, and also the Defense Department in an attempt to stop the deployment of those National Guard troops. Both Mayor Johnson and Governor Pritzker will have more to say during a news conference this afternoon. On the West Side, Judy Wang, WGN News.
All right. Stop that right there. What's going on, good people? It's your boy Jay Tank saying that, ICE is basically forbidden to come to certain parts of the city, which is a joke, right? But he has given CPD, the Chicago, the police department, executive orders to not assist ICE with their ICE raids. And ICE is out here doing their midway blitz. And it's just insane, man, that he will be out here and the governor not willing to work with the federal government, still beyond me. But, it is what it is. But it's just super dangerous. The rhetoric that Brandon Johnson and Governor Pritzker have been using is dangerous. Instead of trying to calm tensions down, right? It's like they trying to escalate tensions. You know what I'm saying? Like the things that they saying. The man was sitting up here talking about Trump trying to start a civil war. Brandon Johnson rhetoric is not making things any better, or Governor Pritzker, But before we get off into my message and the commentary, we definitely got to do this. Flash this disclaimer. I got a lot of content for y'all tonight, so bear with me.
Law enforcement agents, you're using deadly force. and they can use deadly force in response to stop you. We need to be clear about these laws. We cannot become a society where we just decide to take everything in our own hands and start to commit crimes against law enforcement. It is a crime. You may not like what they're doing. I can understand that there's a lot of emotions out there, but that does not mean that you get to commit a crime, especially one that could lead to deadly force. We need to keep everyone safe. Our responsibilities when it comes to federal agents, and I've been asked these questions, we do not interfere with the duties and responsibilities of federal agents. So all the
man, that right.
Arguments regarding the Voting Rights Act. The Supreme Court on Wednesday appeared ready to strike down a 2024 congressional map that a group of voters has challenged as the product of unconstitutional racial gerrymandering that is, according to them, it sorts voters based on race in violation of the 14th Amendment's Equal Protection Clause. During nearly 2.5 hours of oral arguments, the court's conservative justices signal that they are likely to undermine a key provision of the Voting Rights Act, even if they may not ultimately strike it down altogether. So Wednesday's oral argument was the latest chapter in a dispute that dates back to 2022, when Louisiana adopted a new congressional map in the wake of 2020 census. Roughly 1/3 of the state's population is Black, but the 2022 map had only one majority Black district out of 6 districts allotted to the state. That prompted a group of Black voters to go to the federal courts. They argue that the 2022 map violated Section 2 of the Federal Voting Rights Act, which bars discrimination in voting practices. U.S. District Judge Shelley Dick agreed that the 2022 map likely violated Section 2. She prohibited the state from using the map in future elections and ordered the state to draw a new map with 2 majority Black districts. The U.S. Court of Appeals for the Fifth Circuit upheld that ruling. It gave the state until January 15, 2024 to enact a new map or face the prospect of the lower court would adopt a plan for the 2024 elections.
What's really going on about this is American law, Constitution law as it's been interpreted and applied over the last 230 some years, has allowed remedies to correct prior wrongs, okay? The Civil Rights Act of almost 60 years ago, Voting Rights Act, was such a correction. But the wrong, to all intents and purposes, has been corrected, as exemplified by the fact that we have had somebody that at least nominally is part of the protected group holding the highest office that you can hold in America, that is President of the United States. That would be Obama. Senator, member of the U.S. House, commanding general of the U.S. Armed Forces, that would be Colin Powell, as chairman of the Joint Chiefs of Staff. Let's see, you've had a chief of staff for each of the military agencies being part of the protected group. You've had a secretary of state. You've had attorney generals. You've had the whole panoply. So there is no office that the protected class is not held, and it isn't a fact. In more local politics, they control the political outcomes in just about every one of the largest cities in the United States. That would imply that the purposes of the provisions of the act have been accomplished. And when the reason for a law ceases to exist, so must application of the law, and that's the general theme behind the whole thing. The equality of circumstance in American law would dictate that if this situation was allowed to stand as it is now, then there would have to be precincts or districts where they're predominantly Jewish, predominantly Asian, perhaps breaking that down to Filipino, Chinese, Japanese, Taiwanese, Korean, you name it. There'd have to be a situation where you could say they have to break it down so they're Protestant districts, Catholic districts, Jewish, well, we already went there, Jewish districts, Buddhist districts, Hindu districts, and that kind of thing. We've got a new heavy contingent from India, so you would have to have Hindu districts and such like, and that gets a little preposterous because that defeats the purpose. And there's an underlying assumption to this whole thing that is not mentioned these days because it's long been water under the bridge, and that is that the interest of white people and black people are so diametrically opposed that there's no realistic opportunity for a black candidate to win in a district unless it's predominantly black, and there's no commonality of interest between black voters and white voters. So what happens, we have Letitia James in New York, Vivica, well, not Vivica, I know her, Fox in Illinois, you have the mayor of New York, you've got Fannie Willis in Atlanta, you've got LaButte in Atlanta, you've got black sheriffs all around the country, including here in Memphis. So in these former bastions of what was the carryover from a very racist situation 60 years ago, the purpose for the law no longer exists, and it's part of this thing that you see from the left about why would anybody black vote Republican? Well, there are a number of reasons why so many blacks have decided to vote Republican. But the general operative theory is that it would be impossible for the interest of the black residents or constituents to be represented by anybody white, or the interest of somebody white being represented by anybody black. So there is that operative assumption in the whole scheme, and it's somewhat obsolete. So when you come up with this thing nowadays, it runs into the same problem that affirmative action ran into when it was race-based. We've had this discussion before. If the basis for something is neutral, it's permissible even if it has a primarily racial effect to under certain circumstances. But you cannot say black people need to have a particular set aside, therefore there should be a quota, either so many black employees out of so many in total, or so many black students admitted out of such and such total, or so many black districts out of so many in total. See, the American system doesn't really embrace quotas except as a remedial matter. And what we have right now with the way the Voting Rights Act is set up and the way the districts are now being set up essentially establishes a district-styled quota. And that's not permissible under American law, at least not under the current circumstances. So it is what it is. It's like, take my show. When I first got it, they wanted to make it a black show. And I said, no, I'm not going to have it a black show. It's going to be an American show with a black man running it. All right? And it wound up being number 1 or 2. And see, Hollywood's predicate was that no show operated by anybody black could make it in the mainstream, but I said, yes, it can. So it wound up number 1 or number 2 with the most viewers over a 10-day period in the country. So it worked, and that had nothing to do with the fact that you had to limit it to something black. So you get these things where right now the popular conception is looking at Jasmine Crockett's. They're looking at Cory Booker's, they're looking at Maxine Waters, and they're saying this is crank stuff. They're looking at AOC, and they're saying this is, you know, what the districts are entitled to select, but this doesn't have anything to do with mainstream black, white, brown, red, yellow in Texas, New York, Los Angeles, or anywhere else. This is just something that's over there on the far left that is operating under the cover of getting something black. It's like voting as a state for Washington, D.C. doesn't work. Why? Washington, D.C. has maybe 300,000 people as a city, a municipality, but 300,000 people would be a very, 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 very small state, and there's no justification for having 2 U.S. senators represent that few a number of people, nor to have 2 U.S. congressmen representing those few people, and the purpose is to give the far left enhanced influence in Congress. So that's kind of what is being complained about in this case, is it's just a dodge to get undue influence for a certain far left political perspective that has nothing to do with black, white, brown, red, yellow, and is being effectuated by the artifice of having a quota for congressional districts.
But the far right, the Republicans, can be doing the same thing as well.
Well, but the point is, I voted for Trump. A whole lot of black folk I know voted for Trump. So what is the alternative being used? Is there a viable candidate, which I suggest right now can be elected in a varied district? It doesn't make any difference what the person is. But you see, the objective is to get a black female elected, or secondarily, maybe the right kind of black male elected who would push a certain agenda. And the problem is that that's not necessarily the case, because there are black Republican candidates, and they thrive in Republican-dominated districts, which come up when you just set the districting based on other criteria besides race.
I want to play this clip, and I want to play a couple of clips from the hearing. And right here is a clip from the attorney. She is attorney for the NAACP legal defense team, Janae Nelson. I hope I'm pronouncing her first name right, Janae or Janae. And it's 34 seconds. And what she said is pretty interesting.
That's right. And in the state of Louisiana, that analysis was conducted in the Nairn case. And it was clear that regardless of party, white Democrats were not voting for black candidates, whether they were Democrats or not. And we know that there is such a significant chasm between how black and white voters vote in Louisiana that there's no question that even if there is some correlation between race and party, that race is the driving factor.
Can you comment on the Solicitor General's suggestion at page 20?
All right, so her comments, like she said, white Democrats, white registered people who are white, registered Democrats they don't vote for black candidates. So it's not even about Republican or Democrat. It is, when we talk about white people are most likely going to vote for another white person as opposed to if a black person is running. And black people, vote identity politics the same. So did you hear her quote
I heard
on that?
all of what she said. I heard all of what she said. The problem is that, are you going to get an AOC or a Jasmine Crockett? Is that what you're talking about? Like, I can't see how any sane voter would vote for somebody like that, whatever their ethnicity or the demographics. But is that what we're really talking about? You can't get that kind of person involved in the process and successfully elected. And here's what the issue really boiling down to is not that certain demographics won't vote for other demographics, just won't vote for the political perspectives that are associated with a certain demographic. If that makes sense. In other words, would the district vote if there was a Clarence Thomas running for office? Would you get white votes for somebody like that, conservative? Yes, probably you would. But if you get you reference black as being exclusive domain of a Jasmine Crockett, no, you're not.
And we are talking about the state of Louisiana. And so it's still the South. And, if we are going to assume, maybe the assumption is there's still a good portion of white racist people in the South, or someone who may be white and a bigot that don't want to vote for someone who's black.
Well, that's true to an extent, but the heaviest concentration of black elected officials are in the old Confederacy, the 11 states that seceded from the Union in 1861, and that includes Louisiana. So you have, interestingly enough, the juxtaposed contention that these are the most racist areas in the country, but they also coincidentally happen to be the areas with the highest percentage of black representation.
Right. So I want to play this clip of Ketanji Brown.
I'm not taking one particular position over another. I'm just trying to explain the alternative position, which is reasonable. So let's see what Ketanji Head Scratch Brown says.
But I would ask you to just expound a little bit on why you think then that Allen versus Milligan is relevant, or the fact that we held, or what we held in that case, is relevant to what we're doing here today.
Allen versus Milligan is a nearly identical case. There was a similar challenge where we won on a preliminary injunction that there was a Section 2 violation because the state of Alabama in that case cracked and packed the black community, cracked the black belt. And ultimately, this court found that that was a clear violation of Section 2. Similarly, what we have in Louisiana is a circumstance where Louisiana was constructing a map and had a single district that could elect a preferred black candidate and had an opportunity to draw a second district based on the size and geography of its black population, and chose not to do so in the face of 7 illustrative maps that made clear that they were not dilutive.
And what we in part were considering in the context of Milligan was whether or not to change the Section 2 criteria, the Jingles criteria. Is that your understanding?
That's right. The state of Alabama,
and we chose not to.
The court was very clear about that.
And so the parties, I took your initial starting with Milligan to be a suggestion that we not revisit the determination that we made just 2 years ago that the Jingles test not be revised.
That is absolutely correct. And in fact, appellees on page 11 of their supplemental brief state that they understand that this court answered that question clearly, that the results is a constitutional test, that race can be used to remedy violations, and it therefore isn't making that particular argument. In fact, even the SG acknowledged that race can be used in a remedial form when necessary. So those questions have been asked and answered by this court in Allen versus Milligan, and some parties here recognize that those are closed questions.
That's like I said. Well, that's like it. Race can be considered for remedial purposes. Once the problem is remedied, then there's no longer a need to consider race. So in the 21st century, 2025, has the race problem been remedied such that there is a realistic chance of a black candidate being elected in a predominantly white district? Well, look at Tish James in New York. Look, Fox, his state's attorney in Illinois. You see, look at LaButte as sheriff down in Atlanta. Look at District Attorney Fannie Willis. Look at Mayor Bass in Los Angeles. Look at Mayor Johnson in Chicago. And are you saying that black people cannot get elected in a predominantly white district? Obviously they do. So you have illustrated that the problem is to a great extent cured, and you still get on to something that they need to pay attention to. What about the Asians? What about the Native Americans? What about the Hindus? What about Jews? What about Muslims? What about Buddhists? What are you going to do when you start saying these identifiable ethnic groups, these demographics, are not likely to get somebody elected where they are, and they're underrepresented in the halls of various and sundry legislative bodies, particularly the U.S. Congress? Now, look at the furor that's being generated over the far leftist person running for mayor in New York with his ethnic specifications. So he doesn't have an unrealistic chance. He seems to be getting a lot of play from the media anyway, at least in terms of the views that he's expressing, which do appear to have some traction. What about these people that you're dealing with right here? Do they exist or do they not exist? See, what are you going to do about this guy in New York? Is it his philosophy, his agenda, that renders him a realistic candidate, or is it his ethnicity? See, the argument that is in front of the court right now is predicated on the entire appeal has to do with the ethnicity rather than the agenda. And that's not the way American politics is supposed to work, because if you allow that, then you allow old-time racism to come into play. In other words, you've got favoritism to white Anglo-Saxon Protestant voters.
You want to pick her up?
Oh.
The dog that's making all that goddamn noise.
It's on the far side of the kitchen. So anyway.
All right, I want to play this clip of Clarence Thomas.
Why did the state of Louisiana switch sides since our last argument?
Your Honor, we told the court at pages 1 and 2 of our original opening brief in this case that our predicament in this case presents as good a reason as any for the court to evaluate its voting precedents. We told the court at page 18 of our original reply brief that we thought this would be a different case if the court thought it was worth revisiting the long-standing assumption that compliance with Section 2 is a compelling interest. Your Honor, we thought all along, and in my colloquy with Justice Kavanaugh back in March, we discussed our long-standing position in our state legislative map litigation, where we have taken the position that Section 2, insofar as it requires race-based redistricting, is unconstitutional. This court's re-argument QP squarely tees up that question, and so our duty of candor requires us to give the court our honest answer to that question.
Okay. Can you hear me?
Yeah, can you hear me? Did you hear that?
I heard that. It's the same thing that I just raised in terms of the observations I stated. It's like remedial, yes. As a general policy, no. Mm-hmm. You cannot have the introduction of a protected category as a favored category. There is a difference. In other words, I can't discriminate against you because you are a woman, but I can't act in favor of you because you are a woman. You get the difference?
Yes. Say that again, please.
I can't get against you because you are a woman, but I cannot act giving you an advantage because you are a woman.
Okay.
Neither one.
That makes sense.
That's what they're doing. They're saying black people advantage in this districting versus what happened 60 years ago. They set the Civil Rights Act dealing with voting up so that you could not have discrimination based on race. In other words, there was a perception 60 years ago that blacks and whites were so diametrically opposed in interest that nothing that favored black folk, nothing that accommodated them, nothing that made it neutral would come out of any legislative body that did not have special attention to a process of selecting an adequate number of black representatives to protect the blacks from discrimination by the whites. Now, that's not the case now. There are other interests involved here. The Republican Party is actively trying to solicit black folk. The Democratic Party presumes they have black folk, and they are soliciting the support of black folk to deal with rainbow folk.
All right, so I want to play this next clip of Ketanji.
So in essence, are you saying in response to Justice Barrett that it's a compelling interest nonetheless because the state has an obligation under our Constitution and under Section 2 to provide an equally open electoral process?
That's correct.
I mean, I guess what I'm trying to really wrap my mind around is the different stages of this case and like the different questions at issue, because it's complicated. But I think the beginning of the whole thing is the requirement of equal protection in the Constitution and Congress's determination under Section 2 to make sure that that is being provided to minority groups in the electoral process by having a statute that requires states to provide equally open electoral processes. I mean, that's what we said in Milligan. We were very clear that individuals lack an equal opportunity to participate when a state's electoral structure operates in a manner that minimizes or cancels out their voting strength. I mean, everybody, I don't think there's a disagreement that we have this initial goal, which is providing equal opportunity. And so then the Robinson Court is asked under Section 2, is this a situation in which that's not happening? And they go to trial and they bring in a lot of evidence and they do the thing, and the Robinson Court says, yes, this is that situation. Fine. I guess I don't understand why the Robinson Court's decision is before us right now. Because what I understood is that as a result of the Robinson Court's decision, Louisiana then enacts a map that it believes will remedy the violation that the Robinson Court has identified. And we're here on a challenge about that map. That I think we call as a Shaw problem. We're here deciding whether they can use race as a remedy, as people say they did in the construction of this map. So I guess I'm not even clear why the Robinson Court's initial identification of the problem is being questioned as a compelling interest, because there's an interest in not having an unequal electoral system, right?
That's correct. The Robinson decision is absolutely not before this court. There's no record in the Calais case to support that.
Thank you.
Thank you, Cal.
Why did the state of Louisiana? That from Justice Thomas. See, this goes back to what I was saying. Let me read what I put in here. 60 years ago, there was a great disparity between what the Constitution prescribed as appropriate and what was occurring under law and custom as it existed at the time. The fundamental atmosphere of one of conflict between a historical pattern of negating and depriving citizens of their rights on the sole basis of their perceived race, which a predominant concern at the time was that of Negro, Black, African American, Afro American, and guaranteeing the opposite circumstance of privilege for another, meaning the Caucasian or white race or whatever it might be. Now the deprived class, that is the Negro, is well insulated into the political and social process of the nation, and in fact dominates the whole of the political landscape in the largest urban areas. This is the type of political circumstance that is essentially typical for all ethnic, national, or local demographics. That's everybody else. The 60-year-old Rights Act presupposes that there will be a schism based exclusively on race that will be deterministic of any political agendas, objectives, or outcomes that might come before a legislative body. This schism required for remedial purposes that Negro voting blocks be permitted to ensure that fundamental access to political authority would be available to remedy historical oppression based on race. All traces of that have effectively been reduced to a certain background noise that is no more, no less than the generic xenophobia that impacts the population generally. In other words, there's no one alive now who has been a slave under the auspices of U.S. laws, nor anyone who has ever been able to evoke such offensive laws for personal nor collective benefit. In U.S. law, there is a strongly operated principle of reciprocity, i.e. sauce for the goose is gander as well. If you cannot permit whites to have a legislative advantage or legislated advantage, you cannot give a similar advantage to the Negro, except for remedial purposes. For example, when the reason for a law ceases to exist, so must the application of the law, and if Negroes have political opportunity that is essentially the same as for any other demographic, then there is no longer a justification for remedial compensation and corrective legislation. Going further, that means if you cannot discriminate against one group, say blacks or Negroes, you cannot discriminate against another, say Caucasians or white.